Child support is a body of law completely unto itself. It is not technically part of custody, if there is really anything that is known as custody. Custody is not a really great legal term in the state of Texas. We have titles and rights and duties, and possession schedule makes up what most people consider to be the custody order. Child support is something that is very heavily regulated. As you probably know, if you know anybody that's been through the system, or if you have been through the system, child support is often treated in Texas as a mathematical calculation, although if you look in the Texas Family Code, there's all kinds of variables that the court can consider, and arguably that the court should consider when setting child support. So how does child support work? The presumed way to do it, and the way it's done most of the time, is just looking at who is the primary caregiver of the children, and then that's the person that's going to receive the child support, and then looking at the other person's income. You start with the idea of, okay, how much is the person actually earning and bringing in income? And then you can also consider some other things. So there are cases involving, for example, kids that are in college and they're not earning anything, but the kid's parents are giving him room and board and providing for everything he needs. And so courts can look at that. But generally speaking, what you're looking at is the W-2. You're looking at what the gross earnings are, and then you're boiling that down to what the net earnings are. The Texas AG publishes a chart so that you can plug in what the gross is, and then it will tell you what the net is supposed to be. I know when I was in the Marine Corps, you could make your net be whatever you wanted because you could have allotments going here, there, and everywhere. And so the AG is wise to all of that, and they don't allow you to use your net as it really is, meaning if you have money coming out of your paycheck to pay your car payment and for this and for that, they don't allow you to use that as your net. What they want to use is your net after they've deducted from your gross certain amounts that they think are proper. Generally speaking, the AG's office and a lot of judges and mediators will want to use guideline support, just that mathematical calculation. So you look at what the gross is, you plug it in the chart that tells you what the net is, and then you look at the percentages. One child, it's 20%, two kids, it's 25%, three kids, it's 30%, and so on. It can get more complicated if the person paying the support also has a child or children from another relationship. It messes up those strict 20-25%. But what's interesting is there is no automatic revisiting of that. For example, if you've got a child from another relationship and now you're paying child support for this child, that doesn't mean that first child for which you're paying 20% automatically gets reduced. If you want that to happen, you're going to have to go back in on a modification and argue, now I'm paying for the second child and now I need to reduce what I'm paying for that first child. If you're looking at those percentages, one of the things to keep in mind is that there are sections of the Family Code. One of them is one of my favorite sections. It's section 154.123, and it lists an entire laundry list of items that the court is to consider in setting child support. It gets tricky trying to get the court to consider all of those items, and all of those items have to do with more of a totality of the circumstances analysis. If you look at the entire body of child support law in the state of Texas, you can make an argument that it is supposed to be an individualized decision based upon the totality of the circumstances. But what happens most of the time, it's treated like a mathematical equation. It's what's your gross, plug it into the chart, that tells you the net, and then punch it in with whatever the percentages you're using based on how many children you're talking about, and then that's the number. Once you are ordered to pay that, that amount has to be paid. There's some bad information out there where people hear, oh, unless you're this far behind on it, then you're not really late. Well, yes, you are. If you're ordered to pay your child support on a particular day, if you're 1 day late, then you were late paying that child support, and theoretically, you're in contempt of court. Nobody should be advising anybody to violate a court order. You want to follow those court orders. Just about the only two things I've ever seen anybody be put in jail for in family court is not paying child support and not turning over their children when they're supposed to. So child support must be paid when it's ordered to be paid. and how it's ordered to be paid. If you're ordered to pay it through the disbursement unit, then don't be giving a check to the other parent. Don't be giving a check to your ex-spouse and saying, here, I don't want to go through that. I don't want to do what the orders say. If you do that, you can create some serious problems for yourself. The court is probably going to order a specific amount based on the percentage. If you leave it to a judge and if you come to an agreement, that's what the judge is going to be looking for. I have been in court before and heard a judge say, I will not sign any order that does not order somebody to pay somebody child support. There are particularly old school judges that feel like we don't care if you're doing a 50-50. We don't care about your possession schedule. Somebody needs to be paying somebody child support. Other judges don't seem to care about that. Their attitude seems to be, well, if the two people can agree on how they're going to do it, then I'm going to let them agree on how they're going to do it. But child support is one of those funny things. If the two of you can agree, you can change that custody order anytime you want it, and the court will honor what you do. It can get tricky in terms of enforcement and proving what you agreed to. But theoretically, if the two parents agree, they can work their way around the custody order. Child support is not like that. Once the court orders it to be paid a particular way, that's what they expect to be done. If your spouse says, oh, I know you lost your job, it's okay, you don't have to pay for the next 6 months, or you don't have to pay me for the next year, even if you get them to write that in an email or a letter, that is not a court order, and you can't modify your child support without getting it blessed by the court. So that's the basics of child support. The next part is the medical support. Medical insurance has obviously gotten to be increasingly important over the years. And so with health insurance, the courts want to make sure that children are covered because they don't want the state to end up having to pick up the payments for something that happens to the kids. So generally speaking, if you are the one ordered to pay child support, you are going to be the one also ordered to pay for the child's medical insurance, meaning either you through your employment or a private provider provide health insurance for the children, or if your spouse has insurance and the children are on that insurance, then as additional child support, typically the one paying support is also going to have to pay the other parent for that health insurance premium. So there's regular child support, then there's the health insurance premium, and then there's the uninsured medical issues. And for uninsured medical issues, typically what's done is a court will order those divided 50-50. Again, you guys can agree to whatever you want, and 50-50 arguably is completely unreasonable if one person is making a whole lot of money and the other person's not working at all and doesn't have any way to pay it. But that's just what's commonly done unless you agree your way around it. They'll make a good argument in court. Generally speaking, the non-primary parent pays the basic child support. The non-primary parent pays for health insurance, and then both parents split the uninsured medical bills. Then you get to dental. Years ago, nobody seemed to care about dental with respect to custody orders, support orders, but now they do. So now courts expect there to not just be health insurance, but also dental insurance. You need to look at it the same way. The person paying support is expected to foot that bill, and then the uninsured can be ordered split between the two people. That's what you're commonly going to see with something like that. In addition to the normal child support, the medical support, the dental support, there can also be a lot of other things that are talked about in an order. You can have orders dealing with daycare expenses. You can have orders dealing with private school expenses. You can have orders dealing with extracurricular activities. You can even have something in there about college, although in the state of Texas, unlike some other states, the person paying support is never going to be ordered against their will by the court to pay child support for their child who is in college that is above the age of 18. So as you're going through a case, as you're going through a divorce with children or even just a custody case, you need to be careful what you're agreeing to in terms of emails, text messages, things like that, because you can end up being held to it later in terms of an argument that you've agreed to this, and so then it ends up getting put in the order, or at least it persuades the court a certain way, and the court may say, well, I can't do that, but I can raise your ordinary child support. It is also common when it comes to child support that there be an insurance provision saying that the person paying support is obligated to maintain life insurance so that if something happens to them before the support obligation is completely paid. There will be money. One of the things that I think people need to pay particular attention to and be careful about is something that often gets thrown in, and that's some specific order dealing with how future issues need to be dealt with. My strong advice to people is that they really know what they're doing before they sign off. Collaborative law can be great, but you need to know what it is before you're agreeing to it, or before you agree that prior to taking anything to court, you're going to attempt mediation. Well, you need to know exactly what it is you're agreeing to do. How are you going to prosecute this mediation? How is that going to be dealt with? You can even have provisions that say that people need to arbitrate. Well, you may not even know what arbitration is, and that's a topic for another video, but before you agree that you're going to give up your right to go into court to seek a modification, you're going to obligate yourself to go through an arbitration instead, you need to really understand it and know what that is and what your options are. You can have a lot of other provisions in the custody or support order. You can have things about the tax exemption for the children. You can have things about the right to file taxes on behalf of the children. You can have certain injunctions about what can be done or said in front of the children. You can have orders to participate in co-parenting classes. You can have orders to use certain online services that help parents co-parent. There can be all kinds of miscellaneous provisions in the child provisions of a divorce decree, because again, if you're going through a divorce with children, you're going to have both of those cases combined, and it's going to end up in one long decree that includes all of those property provisions that we've talked about, all of the debt division, all of the custody provisions, all of the support provisions. All of that is going to end up in one big order, which is why those orders and those decrees can be 50 pages, 60 pages, 70 pages, or longer. It just depends on how detailed you want everything to be. If you compare a Texas divorce decree with orders from other states, you will see that ours are typically much more detailed. I've reviewed decrees from several different states over the years, and I'm surprised at how scant their orders tend to be. They'll often just talk about people getting reasonable visitation, whereas our possession schedules go on page after page, trying to cover every possible contingency. So I think that's all we're going to cover in this video. And then in the next video, what we're going to do is talk about the miscellaneous other things, the other parts of a case that can be in a divorce, including a lawsuit against your spouse.